Thank you for being here. I'm going to go ahead and get started. And I'm going to start flying too, by the way, because frankly, I think I'm spending way too much time on the introductions and I need to get into the gist of what we're talking about. So let me see if I can do this without anybody being injured. Share. And of course, now that I've gotten cute and put the PowerPoint up there, launch Zoom meeting, I've done that already. Oh, God, Linda. Let me try this again. Okay, so I'll go here and we're going to go to webinars and we're going to go to Greater San Diego Association. And that should be it. All right. All right, here we go. So I'm going to share. What I thought I was going to do was I thought I was going to share the PowerPoint with you, but unfortunately, as you can see, it is not cooperating with me. Okay, can you all see this? Hopefully you can. And there we go. Excellent. So should be able to see the PowerPoint. Everybody good? I'm going to go ahead and start from the beginning. We will start off with welcome. If you can't see the SDAR logo on the screen, please let me know because it's important to me that you're able to follow along. Greater San Diego Association of Realtors webinars, there I am, there's my phone number. Again, I'm gonna fly through this intro because we have a lot to cover and I wanna make sure I have enough time to hit your questions. So yes, I can see it. Thank you, Shonda, thank you so much, thank you. Always helps to get a little bit of feedback. Okay, good. So there you got my phone number. There you got my email address. Listen, I want to hear from you. If you've got questions about anything, whether it's today or whether it's tomorrow or a week from now, would you please reach out to me? I'm more than happy to help you. I got the greatest compliment last Friday at our new laws presentation in which I was labeled as the forms guy by the attorneys. And so I was really honored by that and honored to actually be able to do the panel with Veronica Kilpatrick, Deputy Commissioner of Real Estate, as well as Robert Sunderland, who is just a brilliant attorney. He is Crest Insurance attorney, and then Gov Hutchinson. So I told everybody that I was only there because the person that was going to be there couldn't make it. So, which I don't know if that was true, but anyway, it was great. I mean, hopefully you saw it. It was just out of control. Those are the kinds of things you don't want to miss. Now I know we taped it, so let me know if you can't find the tape, but I'm sure we did it somewhere on YouTube or something like that. So that being said, that's my name. I'm proud immediate past president of the association. There's my credentials. I've got a couple of them. No big deal. I didn't intend to do any of these things. It just kind of worked out that way over time. If you lead yourself in a positive direction, then you just accomplish things. And so I don't know. I guess those are accomplishments. But some of them, I tell people all the time, I just outlived everybody. It wasn't necessarily that I know more than everybody else. I would like to thank the Greater San Diego Association of Realtors for allowing me to present today. Thank you to our education committee, Donald Tanner, our chair, Rocky Rockhill, our vice chair. Hi, Catherine. You're on the air. Jane Fabulic, our fabulous staff liaison, and of course, David Martin, who kind of puts all this stuff together. Without their efforts, these webinars would not have been possible. Oh, that works. Okay, while we'll probably be conversing on subjects that appear to be legal, I am not a practicing attorney. My trial work is limited to testifying as an expert witness on a variety of subjects, most notably standard of care for real estate licensees. Our conversation today is not intended to be a substitute for the advice of your broker, nor for that of your attorney. Please consult with them as appropriate. Everything I know about real estate, I learned by virtue of my association with the association. You need to be as involved as you possibly can be. There is so much. People ask me all the time, how do we learn all these things like what you know about real estate? And my answer is, listen, you have the same opportunity I have, and that is you get online, you get to talking to people at the association, volunteer, get on committees, things like that. This is where you're really going to learn all of this. Our discussion today is live. So again, Today, we're at 1 o'clock in the afternoon. It is live. It is being taped. If you need to see this later or you want to see it again, it is available on the SDAR website. You go to education, you drop down to webinars, and there you go. Okay. If you're experiencing the live version today, would you please give me some feedback and just let me know if you have questions, because we're going to talk about some stuff today. And I was looking at the material again in advance. And again, I'm the forms guy, right? I'm telling you, I've had trial work on this. So if you think if you think you know everything, that could be a problem. Let's make sure that you're looking at it, with open eyes. I'll break from time to time to address these issues. So today, thank you for joining us. We're going to talk about the residential listing agreement, specifically paragraphs 4 and 5. And then remember, on the first Thursday of every month, we have a live webinar from 10 until 11 o'clock on zip forms. So we're going to go through that. If you know that you're going to be there for the live version, not the tape version, you might want to, write down some questions you have in advance. If you send them to me, then I can go ahead and head us in that direction when I'm doing the presentation, because zip forms is a huge product and it's evolving constantly. So I want to make sure I address whatever issues that you are having. And if you're the only one that sends me questions, then that's what we're going to cover. So it's kind of like in any classroom. We find that when we're doing our classes, the person that says, well, I didn't want to raise my hand because I thought it was a stupid question, but unfortunately it was the same question everybody else had in the room, okay? So contracts, webinars, RPA on Thursdays, every Thursday. So tomorrow from 1 until 2:15, we will have a live webinar on the residential purchase agreement. And I'm trying to remember what paragraphs that were on there. I think we just did 4. I think we're going to do 5, 6, and 7 tomorrow. But be aware. Okay, we're doing it every week. Can't miss it. Okay, it's important. And then, as you know already, today on Wednesdays we do the RLA. Every Wednesday from 1 until 2:15. That's what we're doing today. And then the BRE will pick up. When we finish with the RLA, we'll go into the BRE and we will be covering that subject. That'll take a little bit less time because essentially it's the same document as the RLA, right? It just means I'm listing the buyer instead of the seller. So the most common question that comes up when I'm doing these webinars is, how do I get people to sign it? And so we were going to talk about that, all right? Because a lot of people won't even want to know information about the BRE because their statement is, oh, I'd never signed that. And I often respond with, well, have you ever read it? And the answer is no, I haven't read it, but people aren't going to sign that. I don't know. In our company, everybody gets them signed. We don't have anybody that refuses to sign it. I mean, maybe once in a while, but those are the ones that we don't tend to work with anyway. So, so be thinking about that. Maybe I can change your way of thinking, and then maybe you can help me increase the professionalism in our industry. So those are important things. If you have any webinar subjects that you think would be of interest, please let us know. Education@sdar.com takes you right straight to the source. We're here to help support you and the professionalism of our industry. So we'll come back. I'll have this screen later on at the end so that you can write down this information. But this is our contact information for purposes of these webinars. So thank you all for being here. Let me go ahead and get us started. We're going to talk about the residential listing agreement, and of course now I've lost that too. Oh, here we go. This should be over here. I'm having one of those funny things happen with my computer where it actually locks up on me. Okay, everybody see that all right? I think you can. I can double check. So now we are looking, yes, we are looking at the residential listing agreement. We're talking about paragraph number 4. Okay, so we're going to cover 4 and 5 today. So it's a lot of material, but as I said earlier, I've had litigation on this issue, and it went well for our side, obviously. So we have items that are excluded and items that are included. So again, this is your listing agreement with the seller. So be careful. Rather than just sending the listing agreement to the seller, you want to make sure that you are consulting with the seller. Now, I understand, because I'm a practitioner like you, right? But I understand that a lot of times, your seller's in, Waukegan, Illinois, and you're sitting here in sunny San Diego, of course, gloating, I hope. But I'm going to tell you that you still have an obligation to go through the forms with your seller, okay? And that includes the disclosures, that includes the listing agreement, that includes all this stuff. So, how many times do you get something back from the seller And on 4A, I'm telling you, when I go into brokerage offices and I said, let me see your files, because they've got an audit coming up on Friday, that kind of thing. I go in there and I rarely, if ever, see this form filled out. I mean, rarely ever. Did you ask the seller, so we all know from, remember Real Estate 101, we all have a license, right? So we all had this because I know it's on the state exam. But remember, Real Estate 101, what's a fixture? Okay, and something, we have disputes about that. A fixture is anything attached to the land, right? I can tell you, I can spin that pretty good for you in court. But the bottom line is that what is real property versus what is personal property. And so our license says we have a license to work with distribution of real property, and real property is land or anything affixed to the land. And then there's all kinds of things that spin from that. Now, I'm not going to do a law class for you here today, but you have to understand that, if there's going to be a disagreement over whether something was real or personal, it's not going to go well for you. It's not going to go well for your client. So what's a great time to get that nailed down is when I'm on the listing appointment. And I always tell people, listen, I take a listing input sheet with me on the listing appointment, and I spend time with the seller. Okay, so if I see something that I know is going to create a problem later, okay, so like what item that they're going to exclude. So I see, like, I had a case on the chandelier. So there was a chandelier in the foyer as you go into the front of the house, and it's, I don't know, I look at a chandelier. Do you think that's an attachment? I think it is. I think a chandelier is attached. I think not only is it attached to the ceiling, but it's also permanently attached. I mean, we don't take it down at night and put it away, right? But it also has an electrical cord attached to it, okay? What about my refrigerator? Refrigerator is something that, is it attached to the wall? Now, there are rules, 7 methods of attachment. There are rules that go to whether or not something is a fixture, whether it's fixture appurtenant, right? And so do you really want to get into that? The time to get into that argument is not at trial, okay? I'm going to tell you, you want to cover yourself. You want to make sure you ask your seller these questions. So when you see that chandelier, are you intending to leave the chandelier? Okay, are you intending to leave that refrigerator? How is the refrigerator attached to the property? Okay, so for example, by an electrical cord, maybe that doesn't make it real property, right? Maybe if it's built in, right? So it fit, it's a perfect fit in the wall was created for it, all that kind of stuff. So you see how we can start getting into an argument over whether or not it's whether it's real or personal property. Ed Estes asked a great question one day. He says, what about that stovetop? Some stovetops, you can grab a hold of them, lift them up. They have a little clamp that holds them in place, but you can lift them up and walk away. Is that a fixture? I mean, so, the intent of the parties, there may be no intent unless you actually put it in here. What was the intent of the parties? So I don't make it a big deal out of this, folks, but think about it for a second. If you see something that, if the seller says, this baby carriage has been in my family for 37 years, we attached it to the wall, right? Well, do you intend to leave that, or do you intend to take that with you? So in other words, is it going to continue to be attached to the wall and become real property, or is it going to become personal property that you're going to take with you? So you have to make sure that you itemize these things. So where we see additional items excluded, that's where we would put in those things that could create a fuss, right? If they're going to take off with a fridge, then you need, there's an argument that it's attached to the property, then you want to make sure that you write those things down. So again, I think you need to go through the property, and my assumption is you're listing property in California, which is where your license is tagged, and whether the seller's there or not, you want to go through the property and you want to be able to prove that you did, right? Go through the property and make sure that you itemize those items that are going to be questionable. They're hiring you. You're the professional, so you are the one that's going to have to be looking for these things. It's not just a question of, oh my God, am I going to get paid? Right? You need to do your job. You need to go there to the property, whether the seller is there or not, and you need to look around. And by the way, you're avid, okay? That's going to be important. You need to be doing your avid. So, but additional items excluded, you need to ask the seller, do you intend to take that? It looks like it could be questionable as to whether or not it is real or personal property. So let's get rid of that reference right away. Okay, so it has to show up in here. Is that item going to be included? Are you going to leave that item? So I've had, the kids' storage shed out in the backyard with the playpen and all those things. Excuse me. Are you, the seller, going to be leaving that property, or are you going to take it with you? So when you see something that could create a dispute, then you need to be mentioning that to the seller and getting those items included here, okay? So now I'm going to spin this on you a little bit, and this is, I'm sorry, I got great experiences with this, but okay, whatever's in here needs to be in the MLS. Do you follow me on that? Whatever you put in here, this is why this is so important, needs to be in the MLS. If it is not in here, don't put it in the MLS. So I've had agents who have had to buy washers and dryers for the buyer because they put in the multiple listing service that the washer dryer were included, but they did not include it in paragraph number 4A. Okay, and so then the seller comes back later on and says, well, we changed our mind, we're going to take the washer and dryer with us. Okay, I had a really good lawsuit where the buyer goes through the property, videotapes the property, videotapes the Maytag washer and dryer in the laundry room, and then when the seller leaves the property, the buyer buys the home and moves in, and the Maytags have been replaced with Sears Kenmores. Okay, so of course they bought the property based on the Maytag, right? That's their statement. Okay, I had a personal experience. My first property that I sold back in the 70s, the mantelpiece disappeared, right? I mean, my buyer's looking at it going, we bought the house because of that mantelpiece. Now, you and I both know that they didn't do that, but they were just looking for something to create a fuss about. I ended up buying them a mantelpiece just to keep it from going to litigation. I think that was back in 77. So that was a long time ago, right? But so personal experience with these things, and you and I, listen, we don't make enough money anyway, right? So we want to make sure that we cover everybody. We want to make sure we protect our client. Whatever you have to visually do a reasonably competent, diligent visual inspection of the property anyway. Why don't you go there at the time of the listing appointment, earn your money, and say to the seller, you know what, this is going to be a questionable item. And so if you ask the question, is that going to stay, then that's a questionable item, right? So you need to get that from them. And again, you need your document to mirror what is in the multiple listing service. I can't stress the importance of that enough. And I've seen it happen so many times where agents ended up buying appliances because they just didn't include it in the listing agreement. It's got to be in here, not a seller said, you want to make sure that you include it in here. Am I pretty clear with that with everybody? I hope you're all understanding what I'm talking about. Okay, don't see any questions yet. So, all right, so seller intends that the above items, and so let me see if I can remember how to do this, because this is always fun. My annotation. So I like my little annotation. So I'm right here now. Seller intends that the above items be excluded or included in offering the property for sale, but understands that, one, the purchase agreement supersedes any intention expressed above, right? So whatever's in the purchase agreement between the parties, because remember, this is just the listing agreement. This is the employment agreement between the seller and your brokerage. Okay, and then the purchase agreement later on, if the buyer says, well, in the MLS I saw that it said that the washer and dryer were included, and now they included in their purchase agreement, and then the seller has a problem later on, remember that items that are included in the MLS from your paragraph 8A, you all remember that from your we haven't gotten there yet, but it's going to say that items that are 8A in the purchase agreement is going to say that items included in the MLS are not necessarily included unless you specifically address them otherwise here. So then the buyer pulls up the MLS and it says washer dryer, and the seller says, not my listing agreement, it's not in this paragraph right here, so I'm not going to leave it. So so we want to watch out. That paragraph, by the way, protects the seller from the buyer. It doesn't protect us as the real estate agents or brokers, from what can happen from the buyer. Okay, so those are important things. I hope that helps a little bit. It will ultimately determine which items are excluded and included in the sale. So ultimately, whatever the purchase agreement is what's going to prevail. You want to make sure that you aren't held liable for that, whatever you put in the MLS. And we always have that little sinking feeling in our heart when the buyer comes back and says, well, it said in the MLS that this was included, and then you're looking at your listing agreement and you don't have that in your listing agreement, right? So, let's make sure that we're consistent across the board with what we're doing. And then little I here, broker is not responsible for and does not guarantee that the above exclusions and or inclusions will be in the purchase agreement. So, we don't know. We have to address that as a separate issue, and that would be what we would fall back on to kind of protect ourselves. But as we all know, we cannot guarantee that something's going to be the way that we think it does. That's why every time you address your client, I mean, it's a lot of money, folks. It's not, your commission is not just a lot of money. It's a lot of money to the seller. It's a lot of money to the buyer. Okay, so remember, when you're handling them, you have to handle every single word as a new event and make sure that it's consistent with what you've got in your other documentation. Okay, all right. So everybody good with that so far? I don't see. I've got a peanut gallery here. Sorry. Last week I had an audience, right? Last week I had people in the webinar, with me in the room. And then this week I've got people kibitzing from the board here. So I love this association. This is a great place. Okay, so let's talk about it. Everybody good on paragraph number 8? Let me just make sure that there aren't any questions. Seeing none. Everybody's good with A? Okay, all right. A is a hot topic, I'm telling you. Let's take a look at paragraph number B. And we can come back to A if you think of a question, okay? So I don't want to put you on the spot here, but let's take a look at B. So B, leased or not owned items, as opposed to, that's B1, as opposed to B2, which is liened items, okay? So B1, leased or not owned items, all right? So in other words, you don't own it, you don't have any interest in it, you're leasing it, okay? The following items are leased or not owned by the seller. And so then we get into solar power systems. I frequently hear people call it the solar system, but the only way that a solar system could be leased would be if you could actually lease, Mercury, Venus, Mars, because that's a solar system, right? So this is a solar power system. So we had a really good attorney that was on our risk management and still is, Eric Ginder, and he made a comment at one point. He said, my average lawsuit's about $68,000. And one of the reasons is because, the agent didn't do the visual inspection to see these huge photovoltaic tanks up on the roof of the property and didn't ask the question, do you own those or are they leased, right? So they become a UCC filing, Uniform Commercial Code filing, creates a huge legal issue. And so there's usually a balance owed for about like 68 grand. And the seller is prohibited from taking them with him or her, and the buyer may not qualify for it. And guess what? That's a payment you didn't tell the buyer about. So you need to be visual. You need to go to the property. You need to look around the property. You need to look. Do you see something like that solar power somewhere? Do you see an alarm system? You need to be asking the question, is it hooked up? Hopefully, yes, it is hooked up. Okay, it is hooked up. Are you paying a service for it? Okay, because it's one thing to have an alarm system going off in the property, right, that does there, but it's another thing when it calls the authorities or calls fire, fire department, about a fire or something like that. So now you're starting to talk about monthly bills, and unless you want to pick up that monthly bill, we need to be asking this question. This is a perfect example. Paragraph number 4 is a perfect example of asking the question when you're on site with the seller. You need to be doing this. You need to be going through this. Don't just have them sign an initial, okay? That is not a defense for you, all right? Trust me, it's not a defense, okay? How about that propane tank in the back, okay? Now, by the way, that propane tank may actually be powering the entire property, okay? You need to ask your seller, are you on city utilities, right? Water, city sewer, are you on those, or that propane tank might be an indicator to you that they're not. The propane tank also may be something that is, so the property itself could be on electric, but then you see this propane tank. I mean, you can't miss it, right? It's not like they bury it in the ground. It's big, right? So, I've seen it where people will install the propane tank and it powers the fireplace. I've seen a massive propane tank powering the heated pool. So those are things that, remember, those have to be filled. And so we have to make those disclosures if it's leased or not owned. So in other words, you're just not the owner, but you could be leasing it. We need to notify the buyer as to those items. So this is going to mirror questions in the purchase agreement as well. So you want to make sure that you're asking these questions. How about my water softener? Okay, so I have personal experience with a water softener, right? So we had a property that I purchased that had a water softener in it. It was on a property with a well. And so when it came time for the water heater to go, then all of a sudden the water softener was blocking the water heater. And then next thing you know, oh yeah, just throw the water softener out. Well, that was a huge mistake, right? Because the water softener became an integral part of keeping the property, the pipes doing well, and certainly kept the smell of sulfur down. So, you know, these are things that, you know, you can't miss the solar power system up on the roof. You can't miss the alarm panel inside the house. That's something that's going to be really obvious. That propane tank sitting out there, you know, it's not inside the house, right? It's outside the house. Is that leased or not owned? And then finally, my water softener. Those are going to be items that are going to cost you a lot of money if you don't at least make the observation, okay? So remember, when you go to take the listing, just like the buyer, when the buyer comes to look at the property, you're buying with your senses. So you as the listing agent are listing with your senses. Look around. Don't ignore things, okay? If you see something like that, it might be something that's going to be really important, and it's going to be something that's going to protect you later if you ask the appropriate question, okay? Everybody good with that? That's my leased or not owned items, okay? Then I have, so now lease, obviously it goes back, right, to the other party, but the lease could have a lot of different terms in it. It could have terms that says it doesn't go back, so don't assume anything with that. Let's take a look at paragraph 4B2. Now we're going to talk about liened items. So items that have been financed and a lien is placed on the property to secure payments. Okay, so once again, I'm going to give you that UCC filing. So that UCC is Uniform Commercial Code. So our solar power systems tend to be on that, and they tend to be purchased. So if it's purchased, then it's a liened item unless the seller paid cash for it, okay? All right, so they have been financed and a lien has been placed on the property to secure that financing, okay? Much like we do our trustees deeds in California, okay? So back again, I've got my solar power system, same kind of deal. So in this question is it liened? In other words, you bought it and now you're financing the payments to continue to own it versus you're leasing it with the intention of it either being, excuse me, an open-ended or closed-end lease later on, okay? Everybody good with that? Let me just pull up my, the mouse just isn't working today. Okay, no questions so far. Okay, all right. If you have questions, please pipe up. Windows or doors. Now we're starting to see more and more of this, right? Where we have windows and doors that are electronic, that do things, lighting systems, whatever. Windows or doors are kind of important. You know, you could have financing on that as well. Need to ask the seller that. That's why that box is there. The good news is you can literally use the RLA, the Residential Listing Agreement, as a roadmap when you're going through the property with the seller. You know, I just have some questions for you, and this is what those questions are going to look like. How about my HVAC? So I went out, I bought a home, and I had to have, a month after I buy it, of course, the HVAC stops working. That's how it works, right? Property was built in '82, and here I am buying it in 2017, 2018. And so the first thing was the water heater, right? You know that's going to go 30 days after you buy it. Second thing that goes is the HVAC. Okay, so I am financing my HVAC system, my heating, ventilation, air conditioning system. I am financing that. So I went out and to get the HVAC system, it was fairly expensive, so I financed it. It is a lien on the house. Okay, so I would have to, as the seller, I would have to tell you as the listing agent, there is a lien on the property for the HVAC system. It's a cool HVAC, right? I mean, it certainly keeps the place cold in the summer and warm in the winter. There's no doubt about that, right? But I've got a lien on it, okay? And so we need to make sure that the buyer, remember, when the buyer closes the transaction, it is not likely that you have contacted the escrow company and told them that the HVAC system is being liened. So that's why we try to jog people's memories at the time of the listing appointment so that that does come up later and you are able to address that issue and you are able to take care of it. And it may be something that forwards on to the buyer. It may be something they have to qualify for. Much like my solar power system, you know, that's going to be a much larger expense. And it might be something that the buyer has to qualify for. But if the buyer is not aware of the fact that there's a lien on the property for that HVAC or for the solar power system, then it's going to be kind of a surprise. And remember, we don't like surprises. We like surprises that happen before closing. We don't like surprises that happen after closing. Those are just typically never any good for any of us. Okay. All right. Everybody good? Seller will provide to the buyer as part of the sales agreement copies of lease documents or other documents obligating seller to pay for any such leased or liened items. So remember, the seller is agreeing in the listing agreement that they will later provide the buyer that brings in an offer copies of all these documents, okay? And we need to do that. We're doing that to protect ourselves. At the same time, we're doing that to notify the seller that, you know what, it's coming. When you sell your property, when you find a buyer for your property, these are things that they're going to have to sign off on. And so that is a contingency of your purchase agreement. Remember, your purchase agreement actually has a contingency for the buyer to approve of any kind of documentation that you have relative to a lease or liened item. Okay? All right. Any questions about any of that so far? So far, we're doing okay? Now, it seems to like the mouse now. So, okay. I don't see any questions. Okay, all right. Let's move forward then. I'm going to go ahead and get rid of the drawing that I've done in there. Get pretty good at this, right? So let's go to page 2. Of course, that's not going to work. Why not? Oh, I know why, because I have to go back to being a mouse. And so then we'll go to page, still not going to work. Okay, there we go. Linda, okay, so annotate comes off. Still doesn't want to work for me. Dun, 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 dun. Give me half a second here. Annotation. I'm going to go back to cancel that. There we go. Cancel that. Christmas. That goes away. Okay, 5. So paragraph 4A and B referenced items that were excluded and included, and then we had to also address leased or not owned items and liened items. Now we're going to talk about my multiple listing service, and this is a hot topic. Now, if you've been following the news, right, we have an NAR Model Rule 8.0, which is really a restatement of the old rule. But what's creating a lot of fanfare right now because a lot of exceptions have been granted over the years, you know, and based on market. And folks, I'm going to tell you something, you know, and this is just a plug, but you know, these markets too will change, and people will remember your behavior to them in these markets. So, you know, that's why they've called it clear cooperation. Right? That's why it's called clear cooperation. And some business models, you know, we don't want to cooperate. Some business models say, well, we are cooperating, but we're doing this. Okay, so I get that. And you know what? The world is full of all these possibilities. I get that, okay? All right, but let's talk about it on the form itself. And then later on, I've got some other forms that I want to pull up for you to show you some things, okay? So multiple listing service. So the broker is a participant subscriber to whatever that would be. So in our case here, it would be, let me see if I can pull this up. It would be SDMLS if it's the local association, okay, or could also be what? CRMLS, okay, and possibly others. As a broker, I'm a member of several MLSs around the state because we're doing business in San Francisco, we're doing business in Los Angeles, we're doing business in places, so we've got to become members of those MLSs, and that's kind of the push why we see the issues that we see with statewide MLSs and things like that, okay? So, I mean, I just have to be able to do business. They're not participating with us in data share, so I have to find another solution. So unless otherwise instructed in writing, okay, the property will be listed with the MLS specified above, and that's going to be this information right here, okay? That MLS, all right, so I'm not a member of CRMLS, I'm only a member of SDMLS, so for our purposes here in San Diego County, that MLS is, or if checked, is not the primary MLS for the geographic area of the property. So for example, I can take a listing in San Francisco and put it into the San Diego MLS. Okay, I can do that, right? There's no harm in that. So now we're going to put in here, we're just going to put SD MLS, but my listing is up in San Francisco. So I would check this box that says it is not the primary MLS for the geographic area of the property. Now, there's a lot of arguments for doing that. Unfortunately, they can take a bad twist to them. So for example, sometimes people will put it in their primary MLS in the hopes that they'll be able to double end it. They'll get to do both sides of the deal. In the immortal words of Gov. Hutchinson, so that you can get paid twice is not a defense to the complaint. Okay, and so you should have the property in the primary MLS, but there arguably the SD MLS has better marketing for the property, and the public's going to find it anyway from the SD MLS, right? Because when you input your listing into the SD MLS, regardless of where it is in California, it goes out to a lot of different data sources. It goes out to a lot of different third-party aggregators. We call them aggregators and syndicators, right? People that are actually going to help market the property for you. You may not necessarily need to put it in those other MLSs. Maybe SD MLS is the best one. And like I said, arguably it is, because there's better marketing that happens out of that MLS. Okay, so it is. So in this case, my listing is up in San Francisco, so up in SF. I'm listing it in SD MLS. I'm checking the box that says it is not the primary MLS for the geographic area of the property. All terms of the transaction, including sales price and financing, if applicable, okay, one will be provided to the MLS, all right, in which the property is listed for publication, dissemination, and use by persons and entities on terms approved by the MLS. Okay, so remember, we want to follow the rules. Now, have you had it happen where the seller says, well, I don't want you to put it in the MLS, or I want you to put this in the MLS, and you're sitting there going, well, that would be a conflict between what the rule says that I have signed a contract with, right, versus what the seller is telling me to do. But it's the seller's my client, is I take instructions from the seller, but the problem is you've got a contract with your MLS, okay? So you need to tell the seller, hey, I've got a contract with the MLS. I can't do it any other way. And if you give me a different instruction, then you're helping breach my agreement with my MLS. So it creates all kinds of other problems. So obviously that's a subject you're going to want to talk to your broker about, and clearly talk to your attorney about before you go down that path. But whatever the MLS rules state, you need to be following those rules, okay? All right, so, and two, may be provided the MLS even if the property was not listed with the MLS. Okay, so in other words, we can put it in the MLS, but not, it may not have been with that specific MLS. Seller consents to broker providing a copy of this listing agreement to the MLS if required by the MLS. And one of the reasons we have that statement, of course, is all this privacy issues that we're having currently that we're very protective of, right? We're trying to protect the seller's privacy. And now you have a new form for that. Make sure you're using that new form, and that's your confidentiality form that we now have included in your listing agreement. So in your RLA and on your RPA and on your leases, whether listing a lease or selling a lease or renting a property, we've actually added that new form. Okay, so the form has to do with confidentiality of your client's information, letting them know that there's stuff, once you put it in the MLS, it's not confidential anymore, right? Whatever that is. And so they have to tell you whether or not, something, they want you to hold something confidential. Some things already to keep confidential, but then there's other stuff that the seller may say to you, I want to keep that confidential, okay? So I often use it in my law class when I'm teaching that. I often use the example of, the seller says, my wife died in bedroom number 2, and my first question is, did you kill her? I mean, these are, you might not want this listing, okay? So those are going to be important questions. You clearly want to ask your broker about the answers to those things as well, okay? So seller consenting, I like the fact seller consents to broker providing a copy to the MLS if they require it. And that we have situations with some MLSs where they do require a copy of the listing agreement, and it could be later on down the line if there is an offer on the property, and I know I've seen escrow companies do this where the commission is disparate between the listing agent and the selling agent, the buyer's agent, the seller's agent, that kind of thing, and there's a disparity between them. So like, you know, you are taking less than you are paying the other broker or vice versa, right? That kind of thing. They may want to see a copy of page 1, and this essentially gives you authorization to do that. Remember, you can't share your information with others unless you're instructed to do so by your seller, and this gives you that instruction is to actually share that with the multiple listing service. That's a pretty important concept, right? So like, and I had this happen where, you know, the buyer's, the listing agent on a property, we told the listing agent that we had a buyer representation agreement with the buyer, and the listing agent says, send me a copy of that. And so my response was, sure, send me a copy of your listing agreement with the seller. And then they go, well, no, we don't do that. We would never do that. Okay, well, I'm not going to send you the copy of my listing agreement with my buyer either. Just, you know, rest assured that I have one. Okay, if I tell you I have one, you have to believe that I do, much like I have to believe that you've got a listing agreement or you wouldn't put the property in the multiple listing service, because the penalty for that is pretty harsh, right? Okay, all right, everybody good with that part then? If the seller gives me instructions that I'm okay sending it over to the listing, to the escrow company, then I'm okay moving forward with it that way, all right? Okay, all right, let's go on to, first of all, let me clear all these things here. And let's go into paragraph 5B. He says with confidence, get rid of that, get rid of that, and then I should be able to go to 5B. Okay, so 5B, MLS rules generally provide that residential real property and vacant lot listings be submitted to the MLS within 2 days or some other period of time after all the necessary signatures have been obtained on the listing agreement. So I taught the new member orientation for many years, and I can tell you our MLS does require that. So for most all properties that you would be working with, you have 48 hours to submit the listing to the MLS after you have all of the necessary signatures. And I'm going to highlight this because this is a really big deal. Okay, after all of the necessary signatures have been obtained on the listing agreement, all right? Now, why is that a big deal? Well, you know, what happens if you have Mr. Seller signs a listing agreement, wants to sell the house, right? Mrs. Seller is nowhere to be found. What do we call that? We call that a marital restructuring, right? Okay, so you need to have all of the people who are on title. Linda goes in and actually looks up the grant deed to find out who it is. She doesn't even trust CRS for their information, right? So Linda goes in and looks up the grant deed on the property and says, you know, okay, here is the actual seller on this property, and I've seen 2 parties on that list. So I have, you know, a Mr. and a Mrs., or I have, you know, 2 people on it. I need to have both of them on it. If it's a trust, for example, so for example, the property is held in trust. So now I need to have the trustee sign the listing agreement, and I need something from them that says that they are authorized to sign on behalf of the trust. And it's going to depend. The trust signatory may require more than one person to sign it. Okay, so you need to make sure you're asking those questions at the time of your listing. We're seeing so many properties now that are owned by non-natural persons. So we've talked about natural versus non-natural. So natural person, you know, Bob, there he is, right? But a non-natural person would be anything else. So it would be something, a property held in trust. It would be a corporation. It would be someone signing on behalf of someone else for any reason, including power of attorney. So they are not the actual owner. They are signing on behalf of the actual owner. You need to have everyone who is on title, whether they are signing themselves personally or whether they are having someone else sign on their behalf, everyone needs to be signing the listing agreement. So you remember what I said a minute ago? So I have Mr. Seller on the listing agreement, but Mrs. Seller is nowhere to be found, right? Okay, I don't have all the necessary signatures. If both of them are on the title, both of them are on the grant deed, I need both of their authorizations to sell the property. So think about it this way. I go to sell the property after getting the listing agreement signed. I have an agent brings in an offer, and I'm telling you, I was that agent, okay? I bring in an offer on a property, and then guess what? The agent on the other side gets Mr. Seller to sign it, and then informs me, and I'm trying to get Mrs. Seller. Where's Mrs. Seller? And then then all of a sudden I hear, well, we're talking to her right now about signing it. Well, did she sign your listing agreement? Well, no. Okay, so if she didn't sign your listing agreement, then you did not have all the necessary signatures. You put the property into the multiple listing service. Remember, I'm the rules chair, okay? You put the property into the multiple listing service, which says to the world that you have all of the necessary signatures, okay? So that's going to create a problem because now I'm entitled to a commission. We came to an agreement on the sale. We're just missing one of your clients, and now you're telling me you didn't have your client sign the document before you put it in the multiple listing service. So there's going to be a couple of violations with that as well. Okay, so that's why it becomes kind of a big deal. So you need to make sure you've got everybody on it. And as I said a second ago, you got to trust, right? So trusts are becoming the most common form of ownership in San Diego for sure, and a lot of California, and for a lot of different reasons, taxes, legal, liability, things like that people are taking properties in trust. All my properties are held in trust. Okay, so you need to make sure that when you look up the property, if you've got a non-natural person that owns the property, you need to make sure that you have a document from them that says that in fact they are authorized to sign on behalf of that entity. Okay, it's important. All right. I had a case where the buyer sued the seller, and they sued the seller personally, and the seller happened to be an attorney, and the seller comes into court and says, well, they sued me as an individual, but I don't own the property. I own the property in trust. They sued the wrong person. So the buyer had to turn around, more irritated than anything else. Buyer had to turn around and refile the lawsuit, but now against the trust, because the attorney was smart enough to know that he was being sued individually and he didn't own the property. The trust did. Even if he's the sole signatory, the trust owns the property. Okay, so everybody good with that? I do want to see if anybody's got any questions. Okay, all right. Let's move forward. So you have 48 hours to submit. You have 48 hours. That's Jane. 48 hours to submit all of the submit the listing into the multiple listing service. Otherwise, you're going to get tagged, and that's kind of a rule across the country, right? You're going to get tagged for that. So you have to put it into the MLS within 48 hours of getting all of the necessary signatures. Okay, that's all. It's that simple. I wouldn't put it in there if you don't. If you don't have all of the necessary signatures, and remember, you may not advertise a property for sale without the seller's permission. And if there are two sellers on title and you only have one of them sign, I wouldn't be running any marketing either. I mean, you can check with your broker, but I'm going to tell you, I'm pretty clear that you don't have all the necessary signatures. And so now you might go down the path of false advertising when you're telling people that, in fact, you have something that you can sell when you only have half. And I had that happen in a transaction where I was representing the seller, and the previous agent had on the property had only gotten one signature, and told the other party, well, we'll get around to it, and that didn't go well. And unfortunately, a lot of times these are divorces, and so needless to say, there were lawyers everywhere, and it got very, very expensive. If you have any specific questions or have any specific things that you want to discuss, hit me offline on that. But I can tell you, it's a big deal, folks. It can cost you a lot of money. So I'm just asking you to do your homework, and I'm just asking you to try to do it the right way. So broker will not have to submit this listing to the MLS broker will not have to submit this listing to the MLS if within that time, within the 2 days, broker submits to the MLS an appropriate form signed by the seller. So in other words, now we have our exclusions, okay? There are legitimate reasons why sellers would not want to have their property put on the market. So for example, I'll sign the listing agreement today. I'm going to encourage you to get the listing agreement signed today, okay? Get the listing agreement signed today. But what if the seller says, today is Wednesday. What if the seller says, I don't want you to put it into the MLS until Monday, okay? So you already know that you've got you're going to exceed your 2-day period, right? Because it's Wednesday and Monday is clearly more than 2 days. So that's, seller says, I don't want to put it on the market.
okay? That's a legitimate reason, okay? And so we have a form for that, okay? And we actually are starting to do a whole big presentation on forms. We have a lot of forms for things, to do things. And I was called the forms guru, which kind of surprised me. But so here's the deal. You have the CAR form, which is the standard of care across the state. And then you have the local MLS form, which is standard of care for the MLS here where you are a member. Okay, so I would probably recommend that you use the local form. You'll see that it's very similar to the form that's being used by the state. A lot of times we write stuff here. You know, we have the risk management committee's got how many, 26 attorneys, real estate specific attorneys. And so sometimes we'll write stuff and the state will see it and they'll go, wow, that's a really cool thing. We'll do something like that. And so in one way, we want to share our benevolence with the rest of the state. But in another way, we have things that are very specific to San Diego that, for example, our local area disclosures, I mean, people can't copy that because it's specific to San Diego, right? But things like the seller property questionnaire, that they were the seller's additional disclosures form that we had here in San Diego. And CAR said, wow, that was a great idea. We should go ahead and do something for the state that way. So that's kind of where that form came from. So those are good things. They're meant to protect you. And obviously there's things that are going to be specific to the San Diego area that we're going to want to make sure that we're using here. Okay. Looks like I have a question and 2 calendar days or 2 business days. Okay. So your contract, thank you, Don. So your agreement says all days are calendar days unless stated otherwise, right? When you look at your definition of terms, right? Calendar days unless stated otherwise. So if it's going to be business day, then it has to specifically say business day. Okay. So for example, if the time for performance of a contingency or covenant, or contingency falls on a weekend or a holiday, it shall be the next day. And the assumption is that that is the next business day. And Neil Kale, and God love him, CAR attorney, wrote me this 2-page reason for why we didn't put the word business in the definition of terms. And part of it is just because it's kind of obvious, but there's a whole statutory reason for doing it that way. I thought it was great. I asked him, I said, can I publish that? He goes, yeah, go ahead. So, I mean, it's a great job on that. So to answer your question, it's calendar days unless specified otherwise, and that otherwise would be a business day. But just remember that if the date for performance falls on a weekend or a holiday, it shall be the next day. Okay. So Don, thank you for that. Let me get us out of here. So what's my form? So we've got a seller elects to exclude the property from the MLS as provided by CAR form SELM. Okay, so you can use the state form. I don't think it's going to hurt you either way. I just personally, I like the SDMLS form better. That's just my thing. So, and it even says in here, or the local equivalent form. So I can either use the one created by the state, or I can use the one created by my MLS. And in fact, if you go into our MLS, you're able to fill out that form, online. So you can do that as well. Okay. But I would recommend to you, remember, if you're not going to put the property into the multiple listing service within the required 48-hour period, the required 2-day period, then make sure you have something signed by the seller that says that they understand that you are bound by contract. You have a contract with the MLS to do things a certain way. And so when you go to take that listing and the seller says, I don't want it in the MLS until Monday, okay, I'm having the house painted, I have an unruly tenant. There can be a lot of reasons why the seller doesn't want that to happen. It's not just you double ending your deal, right? So if the seller says, I don't want it to go in the MLS until then, I encourage you still take the listing, right? Because you worked hard to get to that appointment. Let's get that finished. But get the listing, get the authorization to exclude, or the seller's instructions to exclude the listing from the MLS, get those signed, and remember that you must either put the listing into the MLS within 48 hours, or, this is important, you either put it in the MLS within 48 hours of all the necessary signatures, or you send a copy of the listing agreement and the authorization to exclude to the MLS. Just send it to rules@sdmls.com, and then they'll receive it and they'll sign off on it. Now they have it on their list of properties that there are exclusions on, so that when the other agent calls up and says they've had a sign in front of that house for 2 weeks and it's still not in the MLS, they can say, well, hey, I've got an authorization to exclude right here, and it says that we don't have to put it in right away. Okay. So for whatever reason, I'm hoping legitimate, but for whatever the reason is, please be sure you're using the right forms. Please be sure you're filling them out as appropriate. Remember, if you check that box in the listing, when you check it in zip forms and you check that box in this form right here, it'll pull the SELM into your transaction, even if you didn't have it there before. All right. So make sure that you are doing that. Make sure that you are checking the box. Make sure that you are using the appropriate form. Make sure that the seller is signing the form. Be very clear about it. It might help for you to read the form before you ask the seller to sign it, because you're going to have questions about it, like, why am I signing this, right? Okay, there can be, like I said, legitimate reasons for doing that. Okay, but make sure you're doing all that stuff before you put it in the multiple listings, before you, within the 2-day period of time. So again, you have to put it in the MLS within 2 days. If you're not putting it in the MLS within 2 days, you better have an exclusion form. And that you need to send over to the rules department at SDMLS within the 2 days. Okay, so 2 days from when? All of the necessary signatures. So you want to send all those forms over to the MLS. You want to send just the listing agreement and just the exclusion from the MLS form, so that they have it on file. They'll keep a note of it. You've covered yourself, right? And that form, by the way, has a lot of different entries to it. It's going to have entries about, in fact, I'll see if I can pull it up here for you. My mouse back. Okay, do that. I'm going to play this game again. Annotate. And I don't want to annotate. I want a mouse. Get my mouse back. Do it. Okay. All right. Well, I was hoping I could pull up that form for you. Let me see if I can grab that for you really quickly here. Webinars, there it is. And then, okay. All right, it's not gonna let me do it. Yes, it will. Look at that. Never say no. Okay, done. And again, I don't know if you can all see what I'm doing here, but I want to check 4 and 5. Okay, I don't even have it in there, so I'm not going to worry about it. All right, back to what we were talking about. Says I paused or resume our share. I'm back with paragraph number 5B. So again, do please make sure that you're doing that. If you need help with how to fill it out or going over the conversation with people, I'm more than happy to help you. Remember, I'm a practitioner like you are. What if your photos aren't ready within 2 days? You know what, Don, that is a great question. So here's the rule on photos. So you have to put a photo in the listing within 72 hours of taking the listing. Otherwise, we're going to ding you $150 a day. Okay, so great question. My advice, okay, I got the listing agreement signed today. I encourage you to get the listing agreement signed, okay? Got the listing agreement signed today. I have all the necessary signatures. I know I have to put it into the MLS by close of business on Friday because today's Wednesday, right? But I have a photo shoot that's going to happen on Saturday. Folks, it happens all the time, and we're very understanding of that, okay? So you can submit a variance request. That would be one way to do it. You could also take the first photo with your camera. You know, our phones are amazing cameras. I don't encourage you to do that for your listing, but if it's something you have to do really fast to get the picture in there, then I would probably do that. But here's why. The reason we created the rule was because as markets change, and this market's going to change as well, okay? But as markets change, we see different things happening. So properties are selling so quickly in this economy that agents are never putting a picture in there. And so now we have a whole bunch of properties in the MLS that look like they were, the property was in a blizzard, right? It's just a screen. And so we wanted to avoid that. It's very unprofessional. It doesn't make us look good at all. As agents, doesn't make us look good. So what we want you to do is we want you to at least put a picture of the front of the property in there within the 72-hour period from when you had all the necessary signatures, okay? I don't think it's too much to ask. I think you could at least take a photo of the front of the property, or, Don, you could go ahead and get an authorization to exclude the listing from the MLS until Saturday when the photo shoot occurs, okay? you can do that as well. Just don't put it in the MLS until then. I think you're losing valuable market time, but I think if you can at least take a picture of the front of the property and get it in the MLS right away when the seller says it's okay to do it, then you can still do that. But you know what? When I gave you the example of, the photo shoots on Saturday, I have this happen. It happens all the time, right? So, the MLS is not there to be, we don't think of it as a punishment. That's not what we're trying to do. We're just trying to guide behavior. Okay, we're just trying to get everybody to do things the same way so that there's some consistency. And please remember, if you don't remember anything else, this market too shall change. And so people are going to remember what you did, not what you said. Okay, so they're going to remember what you did. Okay, remember they remember how you made them feel. All right, and so if you've upset other people because of this hot market, what are you going to do when the market changes and it's not hot like this? If anyone here, I do trial work as an expert on market conditions in San Diego. Listen, I'm going to tell you, this too shall change. It will. Okay. So I want to make sure I'm still friendly with the people in all markets. Okay. Because listen, I'm counting on you to help work with me and help me sell my house and help me to help you sell your house. That kind of thing. We're all working together on this, but your question's a really good question. Let's try to remember that there are ways to work this where you either don't put the listing in right away, you wait till the photo shoot, in which case, simple suggestion, authorization to exclude, okay? Or you just take a picture with the front of the home with your cell phone camera. Sometimes it looks pretty cheesy, tacky, I guess you would say, but at least you have the picture, at least you're in compliance, and you're not going to worry about the ticket. If you've priced the property properly, then it's probably going to sell itself anyway, regardless of the market, regardless of the market. Don, does that help? I'm trying to find a solution for what you're doing. Your question is a really good one. I told them in the panel on Friday, I said, I get so many questions from people that say, they call me on the phone and they go, I know the law says, but, and then my first response is, I don't want to hear but, right? Because I'm not going to help you break the law. I'm clearly not going to do that. So, but I always get a kick out of it when somebody calls me on the phone and says, I know the law says, but, and first of all, you don't know what the law says. So for that already, I'm laughing because it's like, do you really know what the law says? You're not a lawyer, right? So let's all behave ourselves. And the key ingredient of all of this is ask the right questions and make sure you ask them of the right people. So remember, again, your broker is there to protect you. So you need to be talking to your broker. You need to be talking to your attorney. If you are the broker, you should be talking to the attorney, right? So, you make sure you get your information from a qualified source. I can help you, but I'm not a substitute for your broker. And I'm certainly not going to, be able to give you any specific information because, I'm not going to compete with what their advice is. And remember, they have to defend you. So I'm not going to be in that position. So Don, thank you. It's a really good question. Okay. Other questions so far where we are? No, seeing none. I'm going to move that out of the way, move that out of the way. So we covered this already. And now I got to get this to stop annotating. Once again, go back to my mouse. Why does it have to be so complicated? Okay, go back to my mouse, and now I should be able to move it. Of course not. Nope. All right. Get rid of that, and then still can't move it. Boom, escape. Nope. Okay. All right, I'm going to go back over here, and I'm going to do new share. My experience has been there's always a way to work around all this stuff. So we're going to go to that, and I'm going to share that. And then now I need to get to paragraph 5C. Okay, so let's talk. It's going to be one of those days. All right, so let's talk about 5C. And this will whoops, okay, it says you can't see it. Resume share. And then again, boy, can you believe these touch screens and all that? I don't want that. I want it to see. Well, let's do new share. Photos. There you go. Can you all see 5C? Hopefully you can. Okay. Yes, you should be seeing 5C. If not, would somebody let me know? Okay, so MLS rules allow MLS data to be made available by the MLS to additional internet sites, okay, so third-party aggregators, syndicators, unless broker gives the MLS instructions to the contrary, okay, broker. All right, seller acknowledges that for any of the below opt-out instructions to be effective, seller must make them on a separate instruction to broker signed by the seller. And that's going to be that other form, okay? Specific information that can be excluded from the internet as permitted by or in accordance with the MLS is as follows. And so here's going to be my exceptions, okay? So property availability on the MLS, address on the MLS. Seller can instruct the broker to have the MLS not display the property or the property address on the internet. Now, you and I know that if the seller chooses that path, that it's probably going to decrease the exposure it's going to have on the market, and it probably take longer to sell, and it may not sell for as much money as the seller would like to get for it. Okay, seller understands. So back over to here, and I'm going to pull this up really fast. I know people are signing off because you got other things to do, but seller understands that either of these opt-outs would mean consumers searching for listings on the internet may not see it, or the property or the address in response to their search. So I've got my feature opt-outs. And so seller can instruct the broker to advise the MLS that seller does not want visitors to MLS participant or subscriber websites or electronic displays that display the property listing to have the features below. Okay, I don't want the features available below. And we're going to talk about comments and reviews and then an automated estimate of value, okay? And I'm going to move along quickly here because I know people have to go. So, so seller understands that, one, these opt-outs apply only to websites or electronic displays of MLS participants and subscribers who are real estate broker and agent members of the MLS. Two, that other internet sites may or may not have the features set forth herein. And three, that neither broker nor the MLS may have the ability to control or block such features on other internet sites. And by the way, that includes in the future, right? Because once you put it on the internet, you know, it's there 2 years from now, 3 years from now. I get that call. I have that call from the buyer. The buyer says, you know, I want you, stop advertising my property for sale. We stopped advertising it the day you close, right? But it's still on the internet. Yeah, I know, but we don't have any control over that. So once it goes out there, it's out there. And the buyer says, well, I didn't sign the listing agreement. I understand. So you need to talk to that aggregator about why they're still advertising your property for sale. I have an obligation by my contract with the MLS to change the listing. So remember, I had 48 hours to put it into the MLS, but any changes that I make, I have to do those within 24 hours. Those rules don't apply to those other party aggregators. They buy our data, and then what they do with them, we don't have any control over. We can't make them take them down. So, but we need the client to be aware of that, okay? So we may not have the ability to control or block those features. We just don't, okay? So comments and reviews, let's look at that. The ability to write comments or reviews about the property on those sites. Your seller may say, I don't want people to tell people about, my pool or how it's green or anything like that. Or the ability to link to another site containing such comments or reviews if the link is in immediate conjunction with a property display. So, a lot of these websites that are out there that we sell this data to give people the ability to write their thoughts about it. And so maybe the seller doesn't want people to see that. So they have the ability to block that. You have the ability when you put the listing into the multiple listing service to allow comments and reviews or not allow it, okay? And that's a checkbox, okay? And then finally, my automated estimate of value. So you've heard it called the Zestimate or whatever. I mean, all these people have their own little name for things, but the ability to create an automated estimate of value or to link to another site containing such an estimated value if the link is in immediate conjunction with the property display, okay? So seller could opt out. Seller could say, I don't want people to be able to do that. And so that's going to be something that they're going to check here if they're going to opt out of it. I think personally should have this initialed as well if the seller is going to check that box, especially since a lot of times it's you and me checking the box and at the seller's instruction, and then later on you don't want the seller coming back and say, I didn't tell you to do that. So maybe you want them to initial that. I think that's something we've missed. So seller elects to opt out of certain internet features as provided by CAR form SELI. So we have a form for that too, okay? Or the local equivalent form. All right. So those are important things to take into consideration. There may be some things that the seller doesn't want the public to be able to do, even though you and I know they're going to find it in some other way anyway. But the burden's on us to follow the instructions of our principal. Okay. So if our seller says to do something, then we need to make sure that we're doing those things. Okay. Everybody good with that? Okay. Questions on any of that? Seeing none. No questions. Okay. All right. Boy, either you're all amazingly good, or you fell asleep a while ago. So thank you. I appreciate your time. I really do. You know, it's valuable to me. So that being said, I'm pretty sure I don't have anything else coming up on that. There is no other page to go to. And of course, you know, I can't get the stored now. So, all right, anyway, kill that. And then now, nope. Yep, okay, C was the last one. Okay, so last chance. Anybody have any questions about any of this material? Let's go ahead and take care of it now. No, so seeing none, let me take you back to the screen, all about us. There's my contact information. I am happy to help you in any way that I can. But if you don't ask the question, I can't help. So, you know, send me questions privately. You can send them to education@sdar.com. I assure you they will get to me, but I want to make sure that you're okay. All right. That being said, thank you all for being here. And I hope you have a truly a fantastic day. I very much appreciate your time. I got one more here. Thank you. Oh, thank you, Shonda. Thank you. Okay, everybody, have a great day today. I look forward to seeing you tomorrow at 1 o'clock. We're going to be talking about the RPA. We're going to get into that again. Okay, we're going to kill it. All right. Thank you all. Take care now.